Every week we like to feature entrepreneurship in the law, and if we are talking about entrepreneurship in the law, again, we're talking to Mark Furman of Tarlow, Breed, Hart, and Rogers. Welcome, Mark.
Hi, Jeffrey. How are you today?
Thank you. Mark, I'm doing just fine. Mark, you keep bringing up different topics. I see you've come prepared again. You're well armed. What's this subject?
Well, businesses get into disagreements, as we all know and talk about regularly here. But and one of my points that I always make is there's no such thing as boilerplate. Make sure an agreement says what you want it to say. Don't assume the law is going to bail you out if your uncommunicated intent isn't in the document. So here we have a case recently decided with two highly sophisticated parties involving very substantial money investing in real estate, and two LLC agreements, limited liability company operating agreements, that contained what's called an integration clause. And that means an integration clause says this is the whole deal. There's no other deal other than what's in writing. The deal can't be amended except in writing. So here you have a situation where the plaintiff and the defendants were partners in this LLC agreement. They each owned membership interests, so they were the equivalent of stockholders in a company. And they had negotiations about transferring the plaintiff's ownership interest into debt, so that instead of the plaintiff owning an interest, the plaintiff would be entitled to payments. And it was a lot of money, millions and millions of dollars. When people think about agreements, and I hate when they get referred to as, I just need an agreement. That's an invitation to future disaster. What you need is an agreement that spells out what you want the deal to be.
And how it's going to work.
And how it's going to work. And what's going to happen if certain events don't occur. Are you conditioning your understanding of the deal on something? You better say it. You better say it, or the implications are going to be enormous. So, these cases need complete communication between a client and a lawyer in order for the lawyer to do his or her job of making sure the agreement expresses your intent. And the bigger the deal, the more important the communication. The point is, if you want something to be part of your agreement, you better put it in, and don't expect the judge to bail you out later. This is a common issue in business, and obviously you can't lawyer up on every vendor you do business with, but important agreements need to be properly prepared, and you need to have good legal representation, and you need to have perfect communication between you and your lawyer as to what not only the specific terms are, but what's the background for the agreement, so that the lawyer can anticipate and understand what's going on.